On the 14th of December 2022, Jordan McSweeney was sentenced to life imprisonment with a minimum term of 38 years for the murder of Zara Aleena on the 26th of June 2022. On the 3rd of November 2023, Jordan McSweeney successfully appealed his sentence, with his minimum term being reduced from 38 years to 33. Now in this video I'm going to go through how the judge at the original sentencing came to award a minimum term of 38 years. I'll then go on to talk about how appeals against sentences work, and then I'll go through the Court of Appeal's judgment to outline why they came to the conclusion that the judge at the original sentencing was wrong to award a sentence of 38 years, reducing it to a sentence of 33 years. To briefly outline the facts of this case, McSweeney had been released from prison on licence on the 17th of June 2022 for an unrelated offence of robbery. On the evening of the 25th of June, he was at the Great Spoon public house in Ilford, where he was ejected after making unwanted advances to a female member of staff. As the evening progressed into the early hours of the 26th of June, McSweeney spotted Zara Aleena walking home, and he followed her before grabbing her and sexually assaulting her, as well as violently attacking her. The brutal assault left Zara unconscious. Zara was later discovered by a couple and taken to hospital. However, due to the significant injuries she endured, she was sadly pronounced dead at 9:58 a.m. on the 26th of June. McSweeney was arrested on the 27th of June 2022 and charged with murder and sexual assault on the 29th of June 2022. On the 18th of November 2023, McSweeney pleaded guilty to one charge of murder and another charge of sexual assault. On the 14th of December 2023, he was sentenced to life imprisonment with a minimum term of 38 years for the murder of Zara Aleena and a further 4 years concurrent for the sexual assault. At the original sentencing hearing, the judge was mandated to award a life sentence as McSweeney had pleaded guilty to an offence of murder. Now, the prosecution submitted during the sentencing hearing that this was a case where the seriousness of the murder was particularly high, given the sexual assault that had taken place during the murder, with which the defence agreed. Now, the starting point for the minimum term was determined to be one of 30 years. The next job for the judge was to consider any aggravating or mitigating factors which would increase or decrease the starting point. The judge determined that the following aggravating factors were present. Firstly, that Zara had suffered inordinately during the attack, and that McSweeney had taken Zara's mobile to prevent her from calling for help. And finally, that McSweeney had committed the offence in the expectation that he would be recalled to custody. Bear in mind, he was on licence for a separate offence. The judge also found that, with the exception of McSweeney pleading guilty to the offence, there were no mitigating factors in his favour. Now, in coming to the final sentence, the judge increased the minimum term from 30 years to 43 years. However, due to McSweeney's guilty plea, she reduced the sentence by 5 years to come to a minimum term of 38 years. She also awarded a concurrent sentence of 4 years for the sexual assault. Now, following the sentence awarded to McSweeney, he exercised his right to appeal against sentence, which I'll talk about in the next part of the video. When someone appeals their sentence, the test that the Court of Appeal will apply is whether or not the sentence awarded is manifestly excessive. And if you think about it this way, sentencing is an art, not a science. Judges have discretions to award more lenient sentences and more severe sentences. If a sentence falls between that bracket of being severe and being lenient, then the Court of Appeal will not interfere. But where a sentence goes beyond just being severe and being excessive to being one of manifestly excessive, then the Court of Appeal will step in to quash that sentence and then reduce it to one which falls appropriately within the bracket for the facts of the case, considering the aggravating and mitigating factors of the offence. So if the sentence is manifestly excessive, then the Court of Appeal will allow the appeal and will reduce the sentence to one that is more appropriate. When McSweeney came to appeal against his sentence on the basis that it was manifestly excessive, he had 7 grounds of appeal, which are outlined in the judgment, which I put a link in the description and which I'll display on screen now. Now, the first ground of appeal was that there was no planning or premeditation for the murder of Zara. It was a spur-of-the-moment action. Secondly, that Zara's mental and physical suffering was limited on the basis that she was unconscious. Thirdly, the removal of Zara's phone was not a deliberate attempt to prevent her from calling help. The fourth point was that there was no evidence McSweeney committed the offence, knowing that he would be returned to custody soon after. Fifth, none of McSweeney's previous convictions were for serious violence or sexual offending. Sixth, the judge gave no consideration to any mitigating factors beyond McSweeney's guilty plea. And finally, the judge should have awarded a 1/6 reduction, not a 1/8 reduction for McSweeney's guilty plea. In essence, from a starting point of 30 years, an uplift of 13 years for the aggravating factors were manifestly excessive. The justices in the appeal agreed with the original judge's determination that the appropriate starting point for the murder was one of 30 years. On the first point of McSweeney's grounds of appeal, the justices agreed with the original judge, stating that McSweeney planned to violently sexually assault a woman, including being prepared to kill in order to complete that action. Therefore, the judge was correct in considering this to be an aggravating factor. On the second point, the justices stated that the original judge was wrong to conclude that Zara had suffered inordinately for it to be considered an aggravating factor, and this was on the basis that she was rendered unconscious and there was no compelling evidence to show that she had ever regained consciousness once she had been knocked unconscious. The justices also disagreed with the aggravating factors relating to the deliberate attempt to dispose of Zara's phone. Other than that, they identified no errors in the judge's approach to sentencing. Addressing the issue of the overall sentence, the justices stated that a sentence well in excess of the starting point of 30 years was justified. And remember, they have to consider the starting point before the issue of credit for a guilty plea is considered. But they concluded that an uplift of nearly 50% was manifestly excessive. The correct starting point, in their view, was one of 38 years. This was then reduced by a further 5 years to reflect McSweeney's guilty plea. As a result of this, McSweeney's appeal was allowed, and his sentence became one of life imprisonment with a minimum term of 33 years. The sentence for sexual assault was not subject to the grounds of appeal and remained 4 years concurrent to the life sentence. In summary, the reason that McSweeney's appeal was successful was that the Court of Appeal justices found that the judge at the original sentencing hearing should not have taken into account 2 aggravating factors. Firstly, that Zara suffered inordinately because she was unconscious, and secondly, that there was no evidence to support the fact that McSweeney had deliberately removed Zara's phone to prevent her from calling for help. They therefore found that an uplift of nearly 50% from the starting point was manifestly excessive and reduced the sentence from one of 38 years to one of 33 years. In their concluding remarks at paragraph 68 of the judgment, the justices stated, "These were abhorrent crimes. They involved a planned, determined sexual assault, followed by a sustained and repeated attack, which culminated in the death of a young, wonderful woman, full of promise and talent, and who was loved by so many. She was spirited, intelligent, and kind." And as stated in the case of Stewart, the period that a murderer must serve does not reflect the value of a life taken away and does not attempt to do so. Thanks for watching. I hope this video has given you some understanding of the rationale behind the justice's decision to allow McSweeney's appeal and reduce his minimum term by 5 years to 33 years. You may not agree with the decision, but hopefully you can understand it. I'd be really interested to know what you think in the comments down below. If you did like this video, then please do consider giving it a like. And if you'd like to see more from me, then please do subscribe to my channel. Thanks for watching. Take care.